Okay, we're just a couple of minutes, excuse me, past the top of the hour, so I am going to kick things off. My name is Paul Carroll, and welcome. Thank you for joining us for today's conversation. I am the director of the Charity and Security Network. We here at the Charity and Security Network work to defend and expand the space for civil society in the face of challenges caused and exacerbated by counterterrorism and national security measures. These include laws that impede humanitarian, peace-building, and human rights programs, financial access restrictions that hamper and cut off resources, and legal and reputational attacks from politically motivated actors designed to shut down NGO work. One of the most prominent measures that create difficulties for civil society is the broad use of sanctions. These include unilateral sanctions like those imposed by the United States, the United Kingdom, or other individual countries, but they also include global sanctions issued by the United Nations. The trend for years now has been that sanctions have become a tool of first resort. They're considered politically expedient and they're touted as a safe policy alternative, but they result in myriad problems for life-saving civil society efforts due to their complex legal nature across many jurisdictions, the negative and devastating impacts they have on populations, innocent civilians, and economies, and the impediments for civil society, us, to carry out this work. Today's conversation will explore the background and the history behind the December 9th, 2022 adoption of UN Security Council Resolution 2664, which established a broad humanitarian carve-out across UN sanctions regimes, including the 1267 counter-terrorism regime. This legally binding resolution affirms that any financial transactions or provision of goods and services necessary for humanitarian assistance and basic human needs are, quote, permitted and not a violation of the asset freeze. We are very honored and very lucky to have top-notch guests today that will discuss the negotiations that led to the resolution's development and adoption. They will talk about the impacts and the current state of play and consider strategies for extending the 1267 regime after the initial 2-year period, which ends a year from now, December 9th, 2024. Additionally, they will explore recommendations for key stakeholders based on an in-depth analysis and recommendations in the Interpretive Note for the UN member states. And we're very lucky to have a representative from Harvard's program on international law and armed conflict who led on this. I'm going to fade to black now and hand this over to Katherine Tomaszewski, our legal analyst here at the Charity and Security Network, who will be leading questions and moderating our panel today. We will save ample time at the end for your questions, and we ask that you submit them into the Q&A icon at the bottom of your screen. Again, thank you for joining us, and without further ado, I'll hand it over to Katie.
Thank you, Paul. Good morning and good afternoon, everybody. Thank you for being here. My name is Katherine Tomaszewski, and I'm an attorney and legal analyst for Charity and Security Network. As Paul noted, this month marks 1 year since the UN Security Council adopted the landmark resolution 2664, which allows for a humanitarian exemption and asset freeze measures imposed by UN sanctions. This humanitarian carve-out created a legally binding exception within the UN sanctions regimes to permit certain organizations to carry out designated humanitarian activities. While sanctions regimes do not explicitly prohibit humanitarian work, as humanitarian activities are protected under international law, as Paul noted, sanctions policies often can create vast difficulties in the operations of humanitarian work, especially asset-freeze sanctions, as humanitarian organizations often require direct and indirect payments for operational necessities in a sanctioned area. Resolution 2664 was a landmark decision because it not only demonstrated the importance of safeguarding humanitarian work and expanded the ability for assistance in places impacted by sanctions, but it reaffirmed that the goal of sanctions should never be to harm innocent civilians who may be living in a sanctioned area and who are the hardest to reach and yet often need humanitarian services the most. Today, we will dig into the years of civil society-led efforts that went into the landmark decision, the impacts we've seen thus far, as well as hear some of the behind-the-scenes details of the negotiation process and what made the resolution come to life within the walls of the UN. We will also discuss the future of 2664, the obligations of member states under the resolution, and hear about what is needed over the coming year to renew 2664 as applied to the 1267 ISIL al-Qaeda regime, and that will be up for renewal next December. We encourage all audience members to engage with the chat and the Q&A throughout the webinar, as Paul mentioned, and we'll be leaving time to answer those questions at the end of the webinar. So please feel free, as you think of them, to include any questions that you have. I'd like to begin by briefly introducing our excellent panelists that we have here today. We have Berenice van den Dries. She is a senior humanitarian policy advisor for the Norwegian Refugee Council. She is based in Brussels, where she currently leads NRC's policy engagement with the EU and member states to preserve principled humanitarian action from the impact of restrictive measures, as well as supporting NRC's global strategy on the topic. We have Alex Hoey here, who is a political advisor at the US mission to the UN and was a key member of the team who led the 2664 negotiations for the US. James Kirk is a legal advisor at the Mission of Ireland to the UN and a barrister specializing in public international law and human rights and international law. Naz Mozirzadeh is a professor of practice at Harvard Law School. She writes and teaches primarily in the field of public international law with a focus on non-use of force, armed conflict, the UN Security Council, and counterterrorism issues. Naz is the founding director of the Harvard Law School program on international law and armed conflict. Last but not least, we will have Sue Eckert joining us a little bit later. Sue is currently a member of the 1267 monitoring team for the UN sanctions regimes against ISIL and al-Qaeda and the Taliban. With more than 15 years in the US executive and congressional branches of government and 20 years in academia and think tanks, Sue is a recognized expert on the use of economic instruments for international peace and security. She also authored Charity and Security Network's 2017 Financial Access for Nonprofits report, which was the first ever quantitative study of the challenges that US non-governmental organizations face in transferring funds abroad to support humanitarian programs. Okay, without further ado, let's begin. We'll begin by speaking with Berenice. Berenice, 2664 came to be as a result of civil society efforts that spanned over a decade. Could you speak to some of that advocacy from the civil society perspective and what strategies you thought were most successful?
Yes, hi everyone. Good morning. Thanks, Katie, as well, and thank you for giving us the opportunity as NRC to speak to this important topic. Thank you also to the other panelists. Maybe a small disclaimer before I go on, as I'm very happy to address the topic and also look into specifically what we thought was some of the key elements that really were instrumental to this decade of advocacy, of collective advocacy, as you mentioned. I'm very happy to speak, but I think it's also a need to recognize the sort of collective work. So I don't want to give any impression that NRC was alone there. In fact, far from it. And I also don't want to give the impression that we got it all figured out, because it's a work in progress and we keep on learning collectively on this. I'm really pleased also that we take the time to take stock also on what has worked and what has progressed since the past year, since the resolution has been voted. I'm sitting here at the EU level in Brussels, where I consistently engage with the EU institution on the transposition and the implementation of 2664. And I can tell also from this global view and the EU view that we've never seen as much progress as in recent years. I think it was really starting since 2018 onward with a massive acceleration since last year and in recent months. And we're seeing that really at the UN level, at the US level, at the EU, in the UK. So it's very encouraging and it's really hopeful. And I'm definitely, as NRC, very thankful to states that are putting the protection of humanitarian space at the core of foreign policy, but also to all the NGOs that have been participating to this. So you asked us to really sort of think through and try to isolate some of the elements that were instrumental to this work. The first one, and I think that's where you expect me, of course, is really recognition of the coalition work. This has been a consistent effort by a great lot of actors over a consistent period of time. In fact, the first report that was documenting the impact of counter-terrorism measures done close at the time was in 2013, I believe, and that was a joint OCHA and NRC endeavor at the time. Since then, there's been so much work by so many colleagues, both in field teams that were constantly helping us to document the impact, as well as humanitarian consortium, like your organization, colleagues in diplomatic hubs, coordination bodies, think tanks, researchers. This was from NGOs, from ICRC, who has been instrumental to this conversation, major UN agencies, and of course, ally states, such as the ones that are attending the panels with us today. I think what was also important is that it's clearly one of the topics in which we had to go and sort of build coalition and build a sort of common messaging and ask across various actors that were also outside the sort of traditional stakeholders. So in this case, really in the past decades, humanitarian actors worked alongside sanction experts, counterterrorism department of treasuries across several states, the banks, the suppliers we work with in places like Afghanistan, and all together in the past 10 years, I think everybody was trying to sort of make sense of something that 10 years ago seems to be a very opaque space where we could see the implication, but it was very difficult at the time to start tracing back the issues to some specific measures. So really for us, this issue of coalition outside of the traditional humanitarian space was also important. And in this coalition work, there was also, I think, several of us that worked into trying to get collective standards up to speed and really making sure that there are some trainings going on for the humanitarian sectors as a whole, from NGOs to local NGOs. NRC, for example, we issued already 2 issues of a risk management toolkit in 2015. In 2020, we're working on the next one. And with the toolkit, what we want to do is really to set standards and really help humanitarian implementers understanding, being able to locate risk associated to counterterrorism and sanction, and then being able to mitigate them. That was the first element on coalition work. The second big piece was, of course, and I think that's another one that's very expected, was the ongoing documentation and evidence base of this work. I think there was an immense leap from the first report in 2013 to last summer. We counted about 40 different reports and body of evidence on these issues. Again, from many different organizations, some looking at the impact of international measures, donor measures, host country measures. In some cases, it was about documenting the risk management system we had internally, or due diligence methods, if it was needed to provide reassurance. I have to say, for the great deal of the 10 years of advocacy, what was the most complicated, maybe in full transparency, was to get out of the loop of documenting the impact. So we had to demonstrate the impact on humanitarian operations, but we needed to move at some point from documenting impact to action. And I think these past years, around 2020 onwards to now, have been really instrumental, with some states showing, demonstrating willingness to move from demonstrating impact into helping us implementing solutions. As NRC specifically, and this, I can't speak for everyone, because there's humanitarian actors, but there's other actors that are also impacted by counterterrorism and sanction. Before NRC specifically, I think that something that may have helped is we also really approach this advocacy from a very impartial position, in the sense that we would always remind that we're not taking a stance for or against sanctions, criticizing the use of sanctions as a foreign policy tool. In fact, we recognize it's a legitimate policy tool, but our advocacy would be strictly sort of targeted and limited to seek to mitigate the impact of restrictive measures and sanctions and counterterrorism measures, whether initially on humanitarian action and of course on civilian as well. So I think this was really something that guided us throughout the conversation, and perhaps came out as an important element that helped us, especially at a moment where at the Security Council level, but also at the EU, the discussion on sanctions became really politicized. And it could be also that some of the work that we were doing would be, or there was a risk it would be recuperated for political gain. So for us, this sort of position that we had in constantly reminding the sort of parameter of our advocacy, I think was important and was key to sort of keeping the conversation going, especially with states during negotiation. Maybe two other elements that I was thinking of is we were also collectively, I think, attentive to unpack a complex problem, but present some sort of, clear or actionable solution at least. So complex problem to overlapping measures, counter-terrorism, sanctions, other restrictive measures, but with one specific ask tailored around the need for, cross-cutting humanitarian exemptions across counter-terrorism sanctions, autonomous UN ones. So this solution was consistent throughout. It was available as early as 2011, I think, in Somalia. States were initially reluctant to consider it, but throughout the message being consistent and being echoed by so many actors, perhaps was an important fact. And then lastly, I think the two other elements sort of go together a little bit with what I was mentioning as well, is that we collectively, again, because of the sensitivity of the issues we were working on and because of the sort of political landscape that was being navigated there, I think there was a careful balance by several actors between, private advocacy engagement and closed-door briefings and meetings with states, as well as public calls when necessary. And this was a constant balance that was being done, also with a lot of a key ingredient to that was also the sort of relationship building and maintaining trusted relationship with actors in several diplomatic hubs. And I think, sort of supporting the allies or helping states allies helping us was I think something that was quite instrumental. And the presence of several states today is also a testament to that. So these are first thoughts around what we thought was helpful, but of course I'd be also interested in the Q&A to hear whether colleagues think there's additional elements that were instrumental to getting to where we are now. Thank you.
Great, thank you so much. Yes, I think that it can't be overstated how important coalition work is in this area, as well as what you mentioned, documenting evidence, but not only documenting evidence, but turning that into action, and presenting one clear solution that can be applied across several contexts is so important as well. So thank you for all of that context. So we just heard about the civil society efforts that were behind 2664, and now we have both Alex Hoey and James Kirk from the US and Irish missions to the UN to speak a bit about the diplomatic efforts behind Resolution 2664. Alex, if we could start with you, are you there?
Yeah, hi Katie, can you hear me?
Yes, I can. Thank you.
Great.
Perfect. So I'd love to start with you. Could you share some background on what sparked the 2664 flame within the UN? There were all these efforts for years and years, and then suddenly it felt like for a lot of civil society, it was finally happening. So we'd love to hear a bit background from the US side specifically on how that came to be. And also, how did some of the civil society efforts that Berenice spoke to play out on the diplomatic end of things? And were there any efforts that were particularly helpful in your negotiations?
Great. Yeah, happy to speak to all of those things. And hello, good morning, everyone. So happy to be here and to talk about this important initiative. So, Katie, I kind of, when you were giving the opening statement just now about, all of the efforts that civil society has been undergoing for a number of years about pushing for this type of initiative, I think that that's exactly right. The United States obviously has very close relationships with many civil society organizations, and we've been hearing about their desire to see something like this for a number of years, and we've been trying to work with them for a long time about balancing some of the longstanding concerns that the United States has about exploring carve-outs to sanctions regimes, both multilateral and domestic sanctions. And I think trying to educate the civil society organizations as well about those concerns that are within certain elements of the United States government, chiefly among them the potential for diversion of aid and counterterrorism concerns. Now, over the years, and then when you said suddenly there seemed like an opening, I will push back on that just slightly. In 2021, the Biden administration came into DC, and the idea of exploring unintended impacts of U.S. sanctions, specifically on the delivery of humanitarian aid, was a priority for the administration since the day that the administration came into office. And so our U.S. Treasury Department underwent a 2021 strategic review of our sanctions programs, looking for exactly that, whether there were, among other things, obviously, but the strategic review was specifically designed to try and see if there were any unintended impacts of our sanctions regimes on the successful delivery of humanitarian aid. And upon the conclusion of that pretty robust and comprehensive strategic review, we did find, in fact, that there were at certain points difficulties that humanitarian and civil society organizations were facing in successfully delivering aid to populations that were in conflict zones that specifically had sanctions levied against them. And so it very quickly became obvious to our administration and across different agencies within the United States government, there was something that needed to be done. And we had also identified, not specifically in our strategic review, because that was focused on U.S. sanctions, but we did note also that UN and multilateral sanctions also played into this, this landscape of unintended negative impacts of humanitarian assistance delivery. And so the United States government decided to undergo this comprehensive and robust approach to trying to mitigate some of those unintended negative impacts, both at the multilateral and in the domestic sense. And we felt that tackling this problem set at the UN from the multilateral space was the most effective way to do so. Multilateral sanctions enjoy much larger support, obviously, than our domestic and autonomous sanctions regimes, and they have wide-ranging impacts. And so we were really excited to try and see if there would be interest from other Security Council members and other member states at the UN to pursue a humanitarian carve-out across all UN sanctions programs. And then obviously, keeping in compliance with our UN sanctions obligations, we would be following suit at the US. And I'm happy to talk about domestic implementation later on in the presentation. But that was essentially how this came to be. Once we conducted our strategic review, we recognized that both our autonomous and multilateral sanctions needed to be reformed. We set out to see how we could best do that. And what we decided was to pursue a carve out in the UN multilateral space. And then obviously that would trigger our domestic obligations to remain in compliance with our UN obligations. And so once we decided that that was something that our system was willing to bear, and of course we worked through a couple of concerns that we had, like I mentioned before, potential diversion of aid, counterterrorism concerns that frankly still exist in our system today. I don't think that they went away with the adoption of UNSCR 2664, but we were able to explore some ways that we could potentially help mitigate those concerns. And again, I'm happy to talk about those later on in the presentation. But we were able to come to a consensus agreement within the United States government that this was something worth pursuing. And then we took it to the UN we began socializing this, I believe, last July and August with several member states before Secretary Blinken made his announcement at the UN General Assembly last September, saying that we would like to pursue this initiative. And then that's when we decided to start working with the Irish. And maybe with that, I can hand it back over to you, Katie, and give James maybe a slight chance to give his perspective as well. If I missed anything, let me know. Over.
No, that's great. Thank you so much. Yes, at this time, I would love to turn it over to James. If you could give us some background on these efforts on the Irish side, as well as the efforts of the Irish from the years prior to push for this type of humanitarian carve out, and what you found to be critical in getting the resolution passed last December.
Sure. Well, thanks, Catherine, and thanks very much to the Charity and Security Network for organizing this event. Very happy to be here. So, I mean, as you suggested, Catherine, before joining the Security Council as an elected member in 2021, protection of the humanitarian space had long been a priority for Ireland. And as a member of the Council from 2021 to 22, it was an overarching priority, including in the context of UN sanctions regimes. And for many years previously, we had been listening closely to the humanitarian community, civil society, and academics who were, as Berenice explained earlier, drawing attention to the inadvertent consequences of sanctions, focusing in particular on how asset freeze measures were hampering the delivery of humanitarian aid. So we were listening to calls for a broad humanitarian exemption to be built into sanctions regimes. And from the outset of our membership of the Council, the adoption of a broad humanitarian exemption was our ultimate goal. But when we began our term on the Council, this goal just didn't seem achievable, at least in the short term, because it didn't seem to have adequate support among the permanent Council members. And so initially, therefore, we focused instead on trying to put the Council on the right path by advocating for the inclusion of relevant humanitarian and IHL language in resolutions renewing UN sanctions regimes. And then around, I think it was summer of 2021, following active discussions within the Council and more broadly with civil society and humanitarian organizations, including Irish NGOs working on the ground in UN-sanctioned environments, we succeeded with others in getting IHL and humanitarian language included in the Security Council resolutions renewing the DRC, CAR, Mali, and 1267 regimes in 2021. And this language stressed that the sanctions measures were not intended to have adverse humanitarian consequences for the civilian population, and recalled the need for states to ensure that their implementation of the measures comply with their obligations under international law, including international humanitarian and human rights law. And the input from humanitarian organizations like the NRC, like the ICRC, really was critical in getting this language inserted into these resolutions. It was really helpful to get concrete examples from NGOs working on the ground of how, in their view, sanctions were negatively impacting on their work. And it was also helpful to get suggested language from organizations like the ICRC, which we could deploy in our discussion with other council members. Now, the inclusion of this language may seem in retrospect to be quite a modest step, and I suppose it was, but I think it was an important stepping stone toward 2664, not least because it began to elevate the issue of unintended adverse humanitarian consequences within council discussions on sanctions. And while this new language was very welcome, it obviously wasn't enough to address the concerns that were being raised by humanitarian organizations and to adequately avoid any unintended negative impacts of sanctions. So that was in 2021. And then I think the next sort of big event was the fall of the Taliban in Kabul and the huge issues that arose there with trying to ensure the maintenance of humanitarian activity, which just wasn't going to be possible if organizations couldn't interact with members of the Taliban who were listed under UN sanctions, under the UN sanctions regime, and were now in power and running ministries. As everyone here will know, the council decided to introduce a broad exemption in that regime. And I think that really started to kind of shift even further the mindset amongst council members as to the need to take broader, or as to the potential need at least, to take broader action and introduce something that would have a more kind of horizontal impact across UN sanctions regimes. And then, as Alex explained, the US was by this stage well on its way toward deciding to pursue something akin to Resolution 2664. And of course, once the US decided that it wanted to take this step and to pursue the adoption of a resolution like this, Ireland didn't hesitate to join forces with the US in this endeavour. And we started to work with the US then as co-pen holder on a draft of what ultimately became Resolution 2664. And as everyone will know, the negotiations took place over several weeks during autumn last year. And we really did try to ensure during those negotiations that we took all perspectives into account, and that we continued to work closely and work closly with and listen closely to the humanitarian activity, and their input, of course, continued to remain crucial to ensuring that the resolution was effective as possible. And during those negotiations, we really had to find a balance between responding effectively to the concerns that humanitarian actors have been raising for years, while also ensuring that there are safeguards against aid diversion, which was, of course, a fundamental concern for many council members and remains so. We think we did achieve this balance. The resolution is wide-ranging, but it's not unlimited. We worked very hard on the first operative paragraph, which introduces the carve-out, and we worked in particular on trying to ensure that the list of those that can benefit from the exemption was sufficiently wide and reflective of the reality of the range of actors involved in humanitarian activity. But of course, the list couldn't be unlimited, and it isn't. And we sought, of course, to develop appropriate reporting mechanisms which would both allay concerns about diversion and serve to help to develop our understanding over time of the impact of sanctions regimes on humanitarian activity. So I think that sort of more or less brings us, more or less sets out the Irish background to and participation in the negotiations. I would just say very briefly in wrapping up that, I mean, you asked, Catherine, what we considered to be critical in getting this resolution passed. And I think with fundamental big shifts like this, there are always so many different factors, but I would really just emphasize two. And I think the first was our partnership with the US in leading the negotiation on this resolution. It's not typical for Security Council members to operate in partnership when co-pen holding like this. And I think the partnership worked really effectively, and is a really good example of how the prospect of good outcomes is increased when you have really effective partnership amongst council members. And then secondly, and I think this is probably a good place for me to end, it was just so critical throughout to have really, really close involvement and input from civil society. And it was actually a real hallmark, I think, of Ireland's council membership overall, that we tried to bring civil society expertise into council discussions as much as possible. And that was, really, really important in the lead up to a negotiation of Resolution 2664 in particular. So I'll leave it there. Thanks.
Thanks, James. Yes, I think that we also can't overstate the magic of what happens when you involve civil society, who often have the most information, the most local knowledge and understanding of what's going on. I think your answer really demonstrates what Berenice was talking about how something that seems so opaque can really be tackled step by step. And, not to write off something that seems too big or impossible just because it seems complex, but rather there can be a step-by-step approach in which that goal becomes more possible. I think that's a great model for civil society to follow going forward. I'd like to turn it over to Naz. Naz, this year, the Harvard Program on International Law and Armed Conflict published its interpretive note for UN member states on 2664, which sought to support the UN member states' efforts to understand and implement key aspects of the resolution. Can you expand on some of the actors who are implicated by 2664 and what their key obligations are under this resolution?
Sure. Thank you so much, Katie, to C&SN for hosting, and to my friends and colleagues on the panel. And before I start, I just wanted to acknowledge that, of course, we are talking about this community and the incredible collaboration amongst the civil society and humanitarian research community at what surely has to be the darkest time that this community has faced, perhaps ever, certainly in our careers, and to just acknowledge that I know that there are many colleagues who are on the call now who are working around the clock and who are perhaps more than ever cognizant of what binds all of us as we try to do to support life-saving humanitarian work in armed conflicts and in situations involving armed actors. So with that, yes, Katie, much to the dismay of many who were forced to read all the pages of our report, we sought to produce a document that would lay out an analysis of the key legal elements and the legal effects of this critical Security Council resolution. I won't repeat what colleagues have said about its significance and the many years of effort by not only civil society and, of course, the co-pen holders, but the many other member states that spent years working on this issue and urging their fellow member states and the Security Council to take this issue seriously. Rather, I'll zoom in on your question about the key audience, if you will, of the resolution. So who has obligations here under 2664? First and most importantly is member states. So member states have, in a sort of shorthand of OP1, which, as James pointed out, is it's the paragraph that we all come back to and are reading most closely. That member states must permit and not consider a violation of the asset freeze to engage in facilitative conduct necessary for fulfillment activities by the specified actors that James mentioned, or appropriate others as determined by the sanctions committees. And in our view, this involves an obligation to review each member state's existing laws, regulations, and policies that touch on these issues, many of which are not expressly tied to any given Security Council resolution, but rather are more broadly implementing sanctions. So to undertake a process of looking within and determining what are the laws, regulations, and policies that each state has in place that may be implicated by 2664. Second, to take action to adjust those laws, policies, and regulations according to 2664. And we've seen some really incredible successes in that area. So as Alex pointed out, the US has taken extensive action on this front. The UK has recently announced a series of measures implementing 2664 and 2664-like language in areas not directly impacted by the resolution, which is a very welcome development, I think, for humanitarian actors. And the EU has taken significant steps to do so, amongst others. So adjusting laws that may involve withdrawing or seeking to overturn particular rules and regulations, modifying them, or adjusting them through other means. And finally, and I think crucially, to communicate that to relevant parties. So Berenice and others in the operational humanitarian community know perhaps better than anyone that it is often private financial institutions that most need to hear clearly from member states how this carve-out is actually creating space for them to then engage in financial and other activities that facilitate humanitarian activity. Second, and I think importantly, perhaps not equally importantly, are Security Council sanctions committees. So through 2664, they have at the very least an obligation to develop and publish so-called IANs, implementation assessment notices, which are not the most of documents to read, but are crucially important in that they convey to member states how a specific sanctions committee reads 2664 into its own responsibilities and mandate. So what does it mean for the carve-out to apply as to the complexities and the objectives of a particular sanctions mechanism? And of course, we have one of the finest experts on the panel to speak more to that work. Third, the Secretary General specifically noted as having an obligation in the resolution to produce a report on the adverse effects of sanctions. And that, of course, has been already carried out in the fall of this year. And finally, the Emergency Relief Coordinator has been requested to provide briefings in respect of these issues to the sanctions committees. And that work, of course, has already begun and is crucial. The final actors I will mention, they do not have, in our view at least, a direct obligation under the Security Council resolution, but an indirect opening or possibility are the providers who can rely on the carve-out. And they are invited to provide information to the Emergency Relief Coordinator, including on, of course, their actions undertaken to ensure prohibited diversion does not take place, but also, and I think crucially, the benefits of the carve-out for their humanitarian work. Thanks.
Thank you, Naz. Now we're going to turn it over to Sue Eckert. Sue, happy you could join us. Sue, the UN 2664, as we've mentioned, is only applicable to the 1267 regime for an initial period of 2 years and is either set for expiration or renewal before next December. This is currently the largest sanctions regime maintained by the UN Security Council. Given your work as part of the 1267 monitoring team, can you speak to the state of play surrounding 2664 over the past year in this context? And what type of information and reporting do you see as critical for the renewal of 2664?
Great, Katie. Thank you very much. Sorry to be late in joining. And we're lucky because I was out in the hall between meetings at the UN, but I found a room that was empty. It's a very rare thing at the UN. Let me just say that I think this is an important session, and I think it's important to take a step back and appreciate what's been accomplished. A lot of people did a lot of work, and member states took the bold and brave position to create the humanitarian exception. And I think that has been enormously helpful. There's a lot of credit to be given, and it was a landmark decision, but we can't rest on our laurels because with regard to application to 1267, it only applies until next year. It was a 2-year application period, and it will expire if not renewed on December 8th, 2024. That's immutable. That there must be affirmative action taken in order to renew this. I also think it's important to note that 1267 is the most impactful regime that this applies to. One, because there are more listed entities and groups. And again, we're not talking about the individuals here. We're talking about the groups and the amount of the number of countries in which terrorist groups control territory. And that's where humanitarians are providing assistance. And that's where this comes to play. So I think it is incredibly important that the community of NGOs be well aware and involved. I have noted some I've come across, they said, well, we dealt with that. And it's like, yes, you did, but you do not rest on your laurels because this is something that is a continuing issue. So a couple points. One, while the 2664 did not create any new obligations on the 1267 monitoring team, it did create expectations. And member states have expected and do regularly ask the monitoring team of whether or not we are aware of diversions. So my role on the monitoring, I've only been there a year, but one of the things that I do is I specifically ask. And you'll probably not be surprised to know that the narrative of diversion and humanitarian assistance benefiting terrorist groups, that narrative exists still. It's cited in broad terms, but when you go in and say, can you provide specific examples? They have not been, by and large, they have not been forthcoming. And I think what it is we're still dealing with the overhang of, diversion, humanitarians, provide support for terrorists. This goes back to, FATF Recommendation 8. So there is an overhang of that. What I will say is that it's very positive in that in asking these questions and trying to get to the bottom of it, we're not seeing any systemic abuse of humanitarian groups. And that is important to note. We said it in, I think we said it in the Taliban report. We have our upcoming report on ISIL and Al-Qaeda, but the questions are being asked. This is an issue on member states' minds. And so I think it's very important that you understand that and that the questions are asked and there's a need for information. I think it's incredibly important the Security Council members have information to make a decision. And so in that regard, I really urge NGOs to report. I know that there are concerns for security and privacy. I know, understand, and appreciate that. But OCHA has briefed all of the committees as of this point. 1267 was briefed last month. And I think that there were some important things that were established. I think that the committee appreciated the briefing, and by and large, it was a really good exercise. I think I'm not going to get into it because details, because these are things, it's the information belongs to OCHA. If we run across any diversions, it is our obligation to report some of these things to OCHA. But I think a couple important points came out of it. One, OCHA did spotlight the ways in which the humanitarian carve-out has made a positive difference. And here, that's a very important thing. I know that most people don't, when you get a success, you don't count on, logging in why it was successful, but it's important. It's important to know that on the positive ledger, that it has actually made an important difference. They also noted, however, and this is to be expected, that some, designated groups undoubtedly and accrue some incidental benefit in certain contexts. And again, we're talking context specific. But some of them are things like taxes and road fees, et cetera. And those things are permitted under the humanitarian exception and under US general licenses, for example. Third, that there is need for more member states to incorporate the resolution into national law. I was surprised when I had a country visit to one country that they had not actually even implemented 2615 because they still had the existing law. This was earlier this year. They then changed the law, and now the humanitarian exemptions can be implemented. But it's important to implement at national level, and I think NAS has done so much good work on that. Overall, I think that, that there was a really high level engagement by the committee with the OCHA briefing. I think that, it's important to note that a number of member states have fully implemented, including the US, the UK, the EU, and others, and that there was progress noted in that there some banks, if you will, and NGOs are reporting a decrease in the number of problems with payments for humanitarian providers. I'll also note that anecdotally, I've had discussions with banks, and one correspondent bank took the resolution and wrote guidance for that particular bank to say, this is how we can now treat and process humanitarian payments, which was very useful. And again, I think important to follow up with financial institutions as well. But the risk of diversion exists, risk of incidental, benefits to designated actors exist. And so I think that what we have to do is to focus on things. OCHA did talk about innovative risk management mechanisms. I think that there is a misperception in many communities that NGOs don't have that. I'm sure everyone who is participating here today has extensive, and the NRC has done so much good work to try to promote effective risk management systems for NGOs. But so noting and just talking about the monitoring mechanisms that NGOs have, I think is important. And I think that, you know, from that standpoint, I think there's really good news, but I think that we cannot take anything for granted. This is something in which information is necessary to make good decisions. And therefore, I really urge, working with NGOs, that you provide this kind of information, you know, regardless of whatever kind of concerns exist with forms of reporting. I don't think the form is important. I think the overall notion of engagement and reporting and having these kind of discussions will be invaluable for the Security Council, the committee, to make the decision to continue this. And, you know, at this particular point, given the positive response so far, I don't think that it has to be time limited. It could presumably be in perpetuity like the other regimes, but that's something yet to be seen. And that's why thank you to Charity and Security Network for highlighting this, because, you know, we're always running up against these deadlines. And so this is a really good bellwether mark here to take stock, to provide, you know, kind of guidance going forward. So thanks very much.
Thank you, Sue. We're running a little bit behind time, which is such is the way of panels. So I want to go through and ask our panelists one final question each. And if the panelists could just keep their answers around 2 minutes, 2 to 3 minutes, and then we'll be able to go to Q&A. We definitely want to leave time for questions. So for the first round, we really spent some time talking about how 2664 came to be, impacts thus far. And now I would like to talk more about the future of 2664. So Berenice, could you speak to, from the civil society perspective, to some of the positive impacts or trends that we've seen in the ability of civil society to operate? And what do you think you see as the way forward for civil society as we look to the future of 2664?
Yes, thanks, Catherine. And don't hesitate if that I go a little bit over the time to just remind me, and I'll just stop and wrap up earlier. So I won't go through so long on the symbolic impact of 2664, because I think a lot of us have covered that on the major signal, the formal recognition of the impact, and linked to the conversation that was highlighting before for NGOs. For us, it also really helped reducing the need to constantly having to demonstrate and to show evidence of the impact of those sanctions on us. It was sort of admitted, you know, acknowledged under formal Chapter 7 resolution that it has an intended negative consequence, and we can move on to the rest. So on the symbol, this is it. On the normative level, of course, it's a major blueprint, both at UN level, but then we also see that trickling to as a sort of new model for the way that can be handled outside of the UN sanctions as well. I mean, from really sad development, and you know, I want to think about what Naz was saying as well. In the most dire times, we hope sometimes some positive normative change can come out of that, and we saw that with the Syria earthquake, which provided also 2664 surely provided a great blueprint for the various general license, EU exemption, UK exemptions, Swiss exemption, Norwegian ones. At the time, so really that facilitated the response to the Syria earthquake. Hopefully we can see some of that for Gaza, but that's for another discussion. So really something in terms of blueprint, it's a model, it's a language, it's something that can be replicated. We know normative change will take a while to trickle down all the way to activities, mostly because there's a lot of actors that need to be involved in the implementation, whether normative or actual factual. But as NRC, I wanted to look into some specifics to kind of give us courage about some positive things we've seen on the ground on de-risking. So really this instance of, you know, banks and the private sector sort of over-complying or not wanting to take risk whenever they're doing transfer for humanitarian actors. In the year following Security Council Resolution 2664, we saw roughly a decrease throughout the year over the span of 12 months, about a third of the payments that were questioned, blocked, investigated, a reduction by a third. That actually worked until October. I checked the number for this morning because I got the November number, and unfortunately in November this year, so last month, we saw again an increase by 200%. So right now, I'm not sure whether the positive impact is completely offset or whether there's something off in relation to the global context, and we need to look into what it is. But I am confident that the resolution had some, and of course the following general license and the outreach to bank had some positive impact on banks, but it also shows that the progress is still volatile, and we always sort of at the mercy of the next crisis. So there's something to keep in mind. In terms of some otherwise operational effect, you know, for NRC, we've been able to purchase and have the legal comfort to purchase Syriatel SIM cards for operations in some parts of Syria where this designated telecom operator is the only designated one. It's not designated by the UN, but as we said, the UN Security Council resolution provided a blueprint for other exemptions, including the one at the EU level, which enabled us to actually work in those parts of Syria and provide SIM cards to our staff and continue being in touch with them. In Myanmar, we'll be able to pay income taxes to where needed, which may not look so compelling, but there's actually a local NGO law that would criminalize tax evasion. So it was actually fairly risky for our team to not do those things. So these are examples of elements. In terms of what's next, and I'll go a little bit further on this, there's still some important work to be done. I think 3 main work streams collectively again. The first one is on the harmonization, both at the level of autonomous or unilateral sanctions, as well as CT measures. In terms of sanctions, we're already seeing great progress. Definitely the US was very prompt to do that with the general license immediately after. At the EU this week, major progress. It was last week, I think. Major progress with the new 10 exemption being announced. So we're seeing a lot of that. At the EU level, there's still some loose ends that can be tied with some regimes like the EU counter-terrorism regime that would really benefit from an exemption a little bit along the line of what was done at the Security Council level on 1267. So on the sanction side and the autonomous, I'm feeling confident, but there's still some work that needs to be done. Something a bit more complicated is on the harmonization of counter-terrorism measures and criminal measures, whether domestic level, international level, so either from donor states or from states that host humanitarian action, because at the moment, some work that can be exempted under Security Council resolution is not necessarily exempted from criminal law provisions. So that still is a major deterrent for both NGO or the private sector. We've seen some great examples in Canada with the passing of an exemption in the criminal law there, and we want to see more of that, because ultimately the main message is until there's harmonization globally across carve-out, in sanctions, in counterterrorism, criminal law, there will still be, you know, unless there's harmonization, basically it will always limit or even at times offset the positive impact of the exemption that already exists. So in short, NGO, we still won't be feeling fully comfortable. They won't be criminally liable for something. And the same goes for banks. So it's still a major issue there. The second thing is on the socialization of the resolution. So that just means making it known by whomever party is involved, and that links to the obligation that Naz referred to. A lot of work is ongoing when it comes to this. It has to be done with host states, again, where humanitarian action is taking place, because we, of course, also have issues with, you know, national domestic counter-terrorism measures. It's the same with banks. We've seen a lot of efforts, again, by the UK, by the US, by the EU on socializing this with the banking sector. In place, we have several states have in place what's called tri-sector working groups. So it would be typically a place where different parts of the government would meet together with the banks and the NGO and talk through practically some of the issues, one of the model. And then my last message is on the plea to continue also risk sharing. And that's a message both for NGOs and donors. We understand the complicated, we understand, but we also just simply aware of the complicated political setup in which those discussions take place. We see that there's increased pressure and scrutiny in some markets also for the work that NGOs are doing. And so you were also making this clear. I think from the NGO side, it's important that we continue, maintain, and communicate about the due diligence standard, the risk mitigation mechanism we have, that we are transparent insofar as we feeling comfortable with our donors and with the states that support us, and that we keep on alert on the risk and we try to mitigate them, that we report to the Security Council resolution if we are able to. That's one piece from the NGO side. From states, it's also really important to not succumb to the temptation of adding new burdens of reporting other measures in donor agreements, because in itself, if we go back to the spirit of the resolution and why it went through, it was also to ease the operation, including the sort of administrative side of it. And so if we see multiplication of reporting requirements or new diligence measures, then it's of course a little bit offsetting the impact. So I hope that was clear, and thanks for that again. Over.
Thank you. Yes, I really want to emphasize 2 points you made that I think are so important. And that is, one, the harmonization of counterterrorism measures and criminal measures. This is something that the Charity and Security Network works on within the U.S. context regarding the U.S. material support statutes, not always being in harmony with what the general licenses are saying. And also just continuing to fight back against this narrative of aid diversion, and continuing to show the evidence that this is not as big of a problem as I think so many people believe it to be. I think that's really crucial to demonstrate that NGOs have these measures in place already and are already experts in, preventing aid diversion. This is not something that anybody wants to be happening. And so I think that that's really crucial as well. Moving on to our friends at the Irish and U.S. mission, James, from the Irish mission perspective, what do you see in the future for 2664 in Europe? And do you see any challenges from your side that need to be addressed in order for 2664 to be renewed with regard to the 1267 regime next year?
Thanks, Alex. Thanks, Catherine. So first on the EU side of this, since the adoption of Resolution 2664, as an EU member state, Ireland has been very actively supporting implementation of the resolution in the EU sanctions context. And the first step, of course, was the application of the carve-out to EU regimes that purely implemented UN sanctions regimes. And that was achieved with the adoption of legislation on the 14th of February this year. Secondly, then, we had to apply the carve-out to mixed UN-EU regimes, which are regimes consisting of both UN-imposed measures and additional EU measures complementing those UN-imposed measures. And this was achieved, again, relatively quickly, when legislation was adopted on the 31st of March of this year for the mixed UN-EU regimes. And this meant that operators didn't then have to distinguish between UN and EU listings in the relevant regions. Finally, then, attention turned to applying a carve-out based on Resolution 2664 to the EU's autonomous regimes. And Ireland has always believed that the full benefit of the 2664 carve-out, and particularly its impact on overcompliance by banks and other service providers, would only fully take effect once the carve-out had been applied not just to UN sanctions regimes, but also to autonomous sanctions regimes. And so we worked hard with other member states within the EU on the complex task of applying or trying to apply the carve-out to the EU's autonomous regimes. And as a result of that work, a humanitarian exemption was applied to a number of autonomous regimes on an ad hoc basis, for example, to the EU autonomous regimes in Sudan and Niger. But then crucially, as Berenice just mentioned, Just last week, we finally had a big breakthrough when the EU agreed to the application of a humanitarian exemption to a further 10 EU autonomous regimes. So this application of a humanitarian carve-out to these autonomous regimes further increases consistency and coherence across UN sanctions regimes and with those adopted at UN level and by other international partners in order to safeguard humanitarian action. And it demonstrates the EU's clear commitment to avoiding unintended negative impacts of sanctions on humanitarian action. And it demonstrates, I think, that the EU is on the right trajectory in this respect. So work continues, and as Bernie suggested, or as Bernie said, there is some more work to be done. Work continues on discussions on the application of humanitarian exemptions to other EU autonomous regimes. But given, I think, the relatively recent adoption of 2664 itself, I think we're very much on the right trajectory at EU level, albeit not complacent. And then as for the future of 2664 generally, and in particular, the extension of its application to the 1267 regime beyond December of next year, I think so far the story is fairly positive, and it's largely a case of keeping the momentum on the implementation of 2664 and on not becoming complacent about the extension of its application to the 1267 regimes. I mean, others will be perhaps better placed to talk about this than me, and Sue has already touched on it in the context of the 1267 regime. But I think at this very early stage, the reporting mechanisms under the resolution are working well. And it's just really important now that, as Sue said, that relevant actors all continue to do their best to play their part in the operation of these mechanisms, including through reporting, which will assist states in considering the extension of the application of 2664 to the 1267 regime next year. And I think it's also important to prepare to present the case for renewal of the application of 2664 to 1267 next year by pointing, insofar as possible, to the positive impact of the resolution, its effectiveness in safeguarding humanitarian activity, and the need for its continued application to the 1267 regime. So I'll leave it there for now. Thanks.
Thank you, James. Alex, from the US perspective, what do you see in the future for the resolution? And if there is one, can you speak to any strategy on the US side for renewal on the 1267 side for next year?
Yeah, Catherine, happy to. And I don't want to belabor the points that my colleagues made prior. I think I'm in a lot of agreement with James on a lot of what we see next for UNSCR 2664. I think the biggest thing for the U.S. is making sure that this resolution is renewed next December. And I'll keep it very, very simple. And that's essentially what we're aiming for. And I think everything that we're doing, specifically within the UN system, to make sure that UNSCR 2664 is properly implemented is all in furtherance of that goal. I very much appreciate other comments by my colleagues about what we see next for the future of sanctions and humanitarian assistance more broadly. But I think in this narrow context of 2664 and making sure that this remains a viable tool to be used and to keep it, it's the integrity of the intention and the letter of the original resolution. We're very much, I think, from a U.S. perspective, focused on a much narrower goal, which is, of course, to renew renew it in the 1267 regime next year. And we believe we can do that by properly safeguarding the effective implementation of the UNSCR itself. James made a really good point just now about, although there are a lot of positive movements within the UN system and with national legislatures to implement 2664, I don't think we can underestimate the fact that there are elements within the UN Security Council that are not as thrilled that we have this broad humanitarian exemption We saw that very much throughout the course of the negotiations last year, that there are, you know, a number of some legitimate concerns about what potentially the impacts of a broad-based humanitarian exemption could bring. And so we are trying, I think, at every turn to safeguard against any criticism of the resolution itself and its implementation. And so the way we feel like we can best do that is obviously encouraging national legislatures to implement the UNSCR, but within the UN system to make sure that all of these stipulations that were in the original resolution, you know, specifically drafting and passing implementation assistance notices to all of the sanctions committees, making sure that the reporting requirements and the reporting guidelines are set and well established by next year. Because I think, you know, our concerns is that if UNSCR 2664 is not implemented to the letter by next December, there are going to be arguments within the Security Council that, you know, the impact or the effectiveness of this resolution is a diminished one. The UN Security Council was unable to effectively implement 2664 by you know, the renewal date, and therefore we don't have enough information about potential diversion of aid. You can see where I'm kind of going with this. What we're trying to do is safeguard against a lot of these arguments that renewing the UNSCR 2664 in the 1267 context is not necessary, or it won't, you know, it's not helpful or anything related to that. So I think that's what we're looking at this. That's the lens we're looking at this from, is making sure that we've got all of the implementation in place and the system set up so that by the time the renewal happens next December, it'll be really, really difficult to backtrack and take it off the table. And I know I'm looking at the time, I'm just realizing we're far beyond. So I will stop there, pending any questions. Thanks.
Thank you so much, Alex. Naz, as we look forward to next year and beyond, what do you see as the most important legally binding takeaways under 2664? And what will it take to make the intentions of 2664 a lasting reality to ensure the continuation of humanitarian activities in sanctioned areas?
Thanks, Katie. I know we're short on time, so I'm just going to agree with much of it that has been said, especially by Sue and Berenice, about sort of how we need to think about this long-term and comprehensively. I'll just make 2 points. The first is, I do think it's important to remember 2664 is a complex resolution. And for many smaller or poorer states, there is an experience of, for 20 years, you have told us we're being monitored, we're being watched, FATF is looking at everything that we're doing, you better comply with this. And all of a sudden, now you're telling us, get on board, implement an exemption. So I think it's important to recognize it's easier for states with huge diplomatic corps, extensive administrative systems, to do the work involved in implementing this. But this is across 14 sanctions regimes. And for many states, there is a bit of a whiplash effect. And I think we need to recognize that and think about what are the things that can be done at the multilateral level to facilitate states understanding 2664 and having realistic options for how to implement it domestically, including recognizing that they may be experiencing a bit of a surprise at the behavior of some of the permanent members of the Security Council as well. Secondly, just a point about 12667, something Sue said, which I think is really crucial for us to hear, is that there is the option of a permanent implementation. It need not be a constant 2-year cycle. And I think that's crucial in the sense that the important narrow focus that Alex mentioned also has an effect on how we talk about the implementation of 2664, in the sense that it forces us back into the frame we've known for the last decade, which is, let's be very careful how we talk about this. Let's be very careful what we say because of CT. That's important. We all understand why. But if we are able to achieve a permanent implementation, we can then move into the genuine work of what it looks like to implement this across the board. Thanks.
Thanks so much, Naz. Sue, last question for you, and you did kind of already answer it, but we have a large audience of civil society at today's event. And so what kind of specific engagement will be crucial for NGOs looking towards the renewal of 2664 for next December?
Okay, thanks. I'm going to choose to answer the broader question, though, too, in terms of what's next, if that's okay. The first extension, as Alex and James and as everyone has spoken of, extension in whatever form, that is the first priority. The second is, as Bernice noted, and as I've had discussions with a number of banks, they said, okay, we understand the humanitarian exemption. We understand general licenses from OFAC. That applies to sanctions. It does not address terrorist financing generally. And that if you don't address that side of things, you're not solving the whole problem. We've had a good portion, so far, but this broader question still is an impediment. And banks have told me, fine on sanctions, there's still a terrorist financing risk, and therefore we're not going to process the transaction, or we're not going to engage with this country. That needs to be addressed. And so material support is an important issue, which has not been taken on, but needs to be addressed. Third, I would say that what we have in terms of stakeholder dialogues, as Bernice mentioned, I think these are incredibly important because what they're doing is there's progress that's been made, but we have a long way to go. So, for example, CSIS just kicked off phase 2 with AID support in the US, and issues that are going to be taken on. I mean, I don't know how far we'll get on material support, but that's a legitimate issue on the table. Issues about incentives for financial institutions, about safe harbor, if you will, and about greater risk sharing. These are all things that need to be discussed, and innovative ideas, and then that shared internationally. So we're also grateful that there's going to be a joining up of these stakeholder dialogues to share across, national bounds about what can be done. Fourth, I would just say education and engagement. That needs to continue. And in this regard, I would also note that just in October, FATF revised Recommendation 8. This is a huge issue. And people who are engaged with it, they think, oh, well, finally. But the point is that in 2016, FATF revised the recommendation, and it was never implemented by financial institutions, by member states, nothing. So I think there is a unique opportunity we have here to take the new recommendation. The guidance and best practices paper is new. And there's a lot of good work that has gone into that, and not only publicize it, but help member states implement it, because I don't think that most member states actually know how to do this. We know that it's been abused in a number of member states to crack down on civil society. That's been very, a big problem. But so I think that's a unique opportunity. Again, education and engagement. Educate with regard to, diversion. People lump everything together. It's not the case. Trying to interfere and manipulate the delivery of humanitarian assistance, as the Taliban has done, like give it to this community and not that, that's not diversion. That's not what NGOs are responsible for. Giving, as SIGAR, the Special Inspector General for Afghan Reconstruction, has laid out well, paying road fees and taxes. Those are permitted. That's not diversion. That's not inappropriate, use of this exemption. So again, trying to be really precise about what we're talking about in terms of the problem. And part of this education too, I don't know how far this will go, but I actually think injecting an element of realism here is very important. This is not a zero risk, strategy, right? I mean, we're asking NGOs to operate in areas, some of the worst in the world, that are insecure, and there is a degree of inherent risk. So it's not zero tolerance approach. Governments or anyone else cannot stick their head in the sand and say, just do it, but don't have any diversion. I think the U.S. inherently has recognized that historically. Since 2014, OFAC has had a non-enforcement policy for inadvertent violations. I think we need to put that on very firm footing in other member states and codify it, because what that does is provide the protection, and it helps to insulate NGOs and banks from these kind of problems. We know things will go wrong. Okay, that's just the way. But what we should do is be prepared for it. We should know about it, have good working relations with the NGOs, that they feel comfortable reporting it, and then move forward based on the experience. So, and NGOs play a critically important role in this. And I expect that through Charity and Security Network and all the other NGO organizations and individually will participate in this process. So thanks again for doing this to Charity and Security Network.
Thank you, Sue, so much. And thank you for that answer. We're going to go ahead and move along to our questions. I think we received about 3 or 4 questions, so we have time for that. I'm going to turn it over to Paul, who's been collecting these questions in the chat and Q&A. Thank you so much again to our wonderful panelists. And Paul is just going to throw out some questions there, and whoever thinks that they would like to answer or is best suited to answer, please feel free to jump in.
Thank you, Katie. This is one of the advantages of having such a deep bench on one of these webinars. 1 or 2 of the questions got answered, in fact, very thoroughly. So I have 3 questions. I'm going to consolidate them. And as Katie said, those that feel best equipped to answer, please just jump in. 2 of them are related. They have to do with, I guess, a more nuanced application of 2664. So the question is, how does it impact heavily sanctioned countries like North Korea and Syria? And this gets into the weeds of regulation. The U.S. Code of Regulation states that this exemption does not apply to blocked persons, nor does it apply to denied persons list and entry list from the Department of Commerce. When whole governments are blocked, how does 2664 help humanitarian actors? There's, I think, a related question regarding Africa. How do we differentiate sanctions and restrictions given the African context and how it relates to this? So that's, I think, a related set. A second question is actually thrown to the whole audience, but I'm not sure the audience can weigh in. Perhaps those of you on the panel can offer your views. How can we engage with the private sector, or those on the webinar from the private sector offer views on the extent to which outreach from policymakers can help? In other words, how can we, in practical ways, allay private sector concerns about managing the level of risk and become less risk averse? Yes, Sue.
So I'll just, in terms of the private sector, this is a really key part of it. And this is why the tri-sector working groups are really important, because the greater understanding, and I will say that in my experience, the biggest benefit has been between financial institutions and NGOs. I mean, government has benefited as well, and they have to be there. But I think that kind of understanding, I think that we have to listen to, there's no question, they're not, they're for-profit organizations, banks are. And often you're not talking about highly profitable accounts, but they still have to do the due diligence and things. So I think there's a couple things. One of the things in the CSIS context we came up with is that if the US government is funding a project, then due diligence has been exercised. And the banks ought to be able to rely on the fact that the due diligence has already been exercised and not have to do their own. That's one thing. Another has to do, I think, again, with safe harbor. In my discussions with banks historically, there are very few things that will do as much as providing safe harbor, provided, again, you have effective internal compliance systems. This is not a get out of jail free card. What it is for those who make the investment and they take the risk and they engage with their NGO partners, that if there are inadvertent violations that have nothing to do with a failure of their systems, then they should be able to be held harmless, or at least, have less penalties and things like that. So those are just a couple ideas in terms of with the private sector.
Thanks for that. Anyone else on the private sector question or the more nuanced
Yeah,
question of
maybe
failures?
one quick element. So some other colleagues within NRC are really running high-level dialogues with banks, really kind of, series of dialogues that are looking at various different options, from tech solutions to others, to the use of Hawala. There's really kind of unpacking specific problems and putting banks together with regulators and NGOs into looking at specific solutions there. In general, the one thing is, of course, a lot of the problem we see is that so tri-sector groups and those dialogue groups definitely work and offer a platform. It's usually not enough, because the banks that we see there usually know us and know compliance and our due diligence and so on, but the intermediary bank often blocks the transfer, and those we don't necessarily have access to or don't know us. Very clearly, banks often tell us that, exactly as Sue said, a high risk, low return customer, what they need is incentives to help us. So on this, of course, it's a major, there's something major to unpack there, but until incentive comes up, at the very minimum, there's the issue of simplification. When it comes to de-risking, the psychological impact of an exemption is almost as important as the normative impact, in the sense that it needs to look simple and it needs to look harmonized. So, for example, if we take the case of Syria, we had a very positive, a lot of exemptions were issued immediately in the aftermath of the earthquake, but different wording, different language, sometimes different NGOs covered, different timing, and so on. And that just makes it, or even with an expiry date, that just for banks makes it way too complicated. And if it looks complicated, they would de-risk. So this idea of harmonized carve-outs is really key. Over.
Thank you. Anyone else on any of these questions? And I should say that we will endeavor to continue the dialogue offline if people want to reach out to us directly at the Charity and Security Network. We are a network after all. We can forward these questions. We can try to connect you with the expertise that you're asking.
Yeah, maybe I'll just say a word about comprehensive country sanctions. So insofar as there is a Security Council sanction regime that includes an asset freeze, 2664 would apply with the particular caveats. If what you're thinking of is individual so-called autonomous or unilateral sanctions imposed by specific states, 266 has no effect on that. And then you would need to be looking to sort of Berenice's point about a blueprint, that can you encourage states to say, this is working, as Sue says, it's working, it's pragmatic, this is a model that can be used. How can you then encourage them to utilize those? But as a legal matter, there is no obligation upon states to take 2664's carve out and apply it beyond the asset freezes of the particular sanctions mechanisms of the Security Council.
Thank you. That's very helpful.
But on that, I would just say I was really encouraged with the EU action, because I think that, for the UN, it's simple, it's required by international law, but the autonomous sanctions, and I know it's not all autonomous sanctions, but for a core group, I mean, they've divided them to, sort of, low-hanging fruit perhaps of autonomous measures, and there are others to be done. But I was really encouraged that they adopted it, and I think other countries follow suit as well. So I think, again, it's a positive sign.
Okay, well, I am going to, I'm sorry, go ahead, James.
No, I mean, given that the EU was just mentioned, I might just kind of quickly echo what the last few speakers have said. I mean, as Naz said, there's no legal obligation under 2664 for entities like the EU or the US to apply its humanitarian carve out to their autonomous regimes. But as Berenice and I think the person who asked the question have explained, the kind of the application of both UN and autonomous regimes in the same zones can cause real difficulty. And so it's really just a question of continuing the good work that I think we're already doing on trying to harmonize the different regimes. As Sue said, the recent progress in the EU is really encouraging, and I think we're on the right track. And it's really just a case of continuing that momentum and continuing that work. And I would really just encourage all of the experts outside of states, whether it be in civil society or academia, to continue alerting states to the difficulties that they face and to continue informing the work of states on harmonization as much as possible.
Thank you, James.
Okay, I think that's at time. Paul, do we have any other questions that we could follow up with after, or are we good there?
No, we're good. Thanks very much for the questions, and I'll hand it back to Katie. Thank you.
Great. Thank you all so much. I think that, as Sue mentioned, this is a great time, a good bellwether time to be measuring the impact we've seen thus far, and then looking forward with one more year until the renewal as applied to 1267, and getting some good information as not only civil society, but also what member states can be doing to implement 2664 to really ensure that the intentions of the resolution are coming to fruition. So thank you all. Thank you to our amazing panelists here today for being here. Thank you all for your attendance. And if you have any follow-up questions, please don't hesitate to reach out to Charity and Security Network.
Thank you.
Thanks, everyone. Bye.
Thanks, everyone.